Good morning, gentlemen. I'm Yogank dohare from Top Tech Consultants, and today I'm going to present on the topic corporate governance. Let's start with the introduction. Corporate governance refers to the system of rules, practices, and the processes by which a company is directed and controlled. It encompasses the relationship between the various stakeholders involved, such as shareholders, management, employees, customers, suppliers, and the community. Good corporate governance requires transparencies in all aspects of a company's operations, including financial reporting, decision making, and communication with the stakeholders. Transparent practices build trust and confidence among investors, employees, customers, and the public. Companies with good governance practices hold themselves accountable for their actions and decisions. This includes accountability to shareholders for financial performance, accountability to regulators for compliance with laws and regulations, and accountability to other stakeholders for ethical conduct and responsible business practices. Good corporate governance also involves recognizing and fulfilling the company's responsibilities to all the stakeholders, not just shareholders, but all the stakeholders. This includes considering the interest of employees, customers, suppliers, and the broader community, as well as addressing the environment and social concerns. Company governance encompasses the framework of regulations, guidelines, protocols, and decisions established to guide the conduct of corporations. Central to governance is the role of the board of directors, with proxy advisors and shareholders also holding significant sway in influencing corporate governance. Many top companies aim to achieve outstanding corporate governance standards. To numerous shareholders, mere profitability isn't sufficient. They expect companies to exhibit good citizenship, which involves environmental consciousness, ethical conduct, and other robust corporate governance measures. Companies should strive to treat all stakeholders fairly and equitably, without favorism or discrimination. Fairness in decision making, composition, practices, and treatment of employees and other stakeholders contributes to a positive corporate culture and enhances trust. Let's move on to the failure of the Crown Casino. The inquiry report highlights deficiencies in Crown's corporate governance procedures, wherein the company enabled money laundering via accounts associated with its Perth and Melbourne casinos. Additionally, it collaborated with junket operators associated with organized crime. The failure of Crown Casino primarily stemmed from various governance and compliance failures that came to light through regulatory investigations and media scrutiny. There were allegations of poor corporate governance practices within the Crown, including inadequate oversight by the board of directors, lack of independence in decision making, and failure to address internal control weakness. These governance shortcomings eroded investors' confidence, trust in the company's management. Crown Casino faced multiple allegations of regulatory breaches, including failure to comply with anti-money laundering regulations, responsible gambling requirements, and other gambling laws. These breaches raised concerns about the company's commitment to the regulatory compliance and responsible business practices. Media reports and regulatory investigations revealed connections between Crown Casino and organized crime syndicate. The investigations also revealed that the dispersed regulation of casinos across various states has led to inconsistencies that money launderers exploit. State-level regulation was deemed inadequate, necessitating national oversight to address conflict between the states. Crown's risk culture played a major role in the company's behavior. Risk management and corporate governance frameworks were undermined. Crown's board members were not kept abreast of crucial matters that they should have been aware of, and the potential hazards to the safety of employees in China were neither adequately recognized nor prevented. Moving on to top 7 principles, laws, regulations, approaches, or theories on Australian corporate governance. On the top, we have Corporations Act 2001. This legislation sets out the legal framework for corporate governance in Australia, covering various aspects such as directors' duties, shareholder rights, and financial reporting. Adhering to the provisions of this Act is fundamental to good corporate citizenship. Secondly, we have ASX Corporate Governance Principles and Recommendations. Issued by the Australian Securities Exchange, that's ASX, these principles provide guidelines for listed companies to promote transparency, accountability, and integrity in corporate governance practices. Following these recommendations is essential for achieving best practices. Thirdly, we have board composition and independence. Ensuring a balanced and diverse board composition with independent directors who can provide impartial oversight is crucial. This helps in preventing conflicts of interests and promoting effective decision-making aligned with the interest of stakeholders. Next, we have stakeholder engagement. Engaging with a wide range of stakeholders, including shareholders, employees, customers, suppliers, and the community, fosters trust and accountability. A proactive approach to stakeholder community is and for consultation is key to being a good corporate citizen. Next, we have risk management and compliance. Implementing robust risk management frameworks and compliance program is essential for identifying and mitigating risks while ensuring adherence to relevant laws and regulations. This demonstrates a commitment to ethical conduct and responsible business practice. Then we have CSR initiatives, corporate social responsibility, CSR. Embracing CSR initiatives that go beyond legal requirements to address environmental, social, and governance issues can enhance reputation and contribute positively to the society. This includes activities related to sustainability, philanthropy, and ethical sourcing. Lastly, we have ethical leadership and culture. Fostering an ethical corporate culture starts from the top, with leadership setting the tone for integrity, honesty, and accountability throughout the organization. Promoting ethical behavior and value-based decision-making reinforces good corporate citizenship. Let's talk about Corporations Act more in the detail. The Corporations Act of Australia is a comprehensive piece of legislation that governs various aspects of corporate entities, their management operations within the country. It encompasses a wide range of legal, commercial, and ethical features. The Act establishes a legal framework for corporate governance in Australia, outlining the rights, duties, and responsibilities of company officers, directors, shareholders, and stakeholders. It sets out directors' duties, including the duty to act with care and diligence, act in good faith in the best interest of the company, avoid conflicts of interest, and not improperly use their position or information. This act protects the rights of shareholders, ensuring transparency and accountability in corporate decision-making process. The act also regulates the issuance, trading, and disclosure of securities in financial markets, aiming to ensure market integrity and investor protection. Talking about the case ASIC versus James Hardie Industries NV 2009, Section Section 180, Part 2 of the Act, known as the Business Judgment Rule, offers directors protection regarding their business decisions, provided they adhere to its stipulations. As previously mentioned, boards of listed and sizable unlisted companies exercise judgment within the realms of responsibility outlined by corporate governance guidelines. For instance, granting approval for a corporate strategy devised by management at James Hardie constituted a business decision. Conversely, in Central's case, signing off on the annual financial report wasn't considered a business judgment, as it entailed fulfilling a duty mandated by the Act, a statutory obligation. Talking about ASX corporate governance principles and recommendations, companies are required to provide clear and comprehensive disclosure regarding their corporate governance practices in their annual reports, ensuring transparency for investors and stakeholders. The principles emphasize the importance of having a balanced board composition with a majority of independent directors. Companies are expected to implement robust risk management frameworks and internal control systems to identify, assess, and mitigate the risks effectively. The principle emphasizes the importance of fostering an ethical corporate culture based on integrity, honesty, and accountability. The case for this is Greensill Capital collapse. The Greensill company had been acquiring invoices from companies with escalating levels of risk. Consequently, the quality of the underlying assets supporting Greensill security had deteriorated over time, mirroring the situation with mortgage-backed securities during the previous financial crisis. Even after engaging in discussion with alternative firms, Greensill was unable to obtain a fresh insurance provider. Consequently, with the Greensill's insurance coverage lapsing on March 1, 2021, the fate of Greensill Capital was ultimately determined. The BaFin inquiry suggested that the anticipated funding Greensill relied on, which was tied to future receivables, was predominantly fictitious. As a result, Greensill Bank was liquidated. Moving on to board composition and independence, board composition involves determining the appropriate number of directors and their qualifications, skills, and experience. Independent directors play a vital role in providing objective oversight of management, monitoring corporate performance, and safeguarding the interest of the shareholders. Why independence is crucial, it's essential to strike a balance between independence and industry expertise or institutional knowledge. We have two very famous cases for this one. Bankruptcy of OneTel, the fourth largest telecommunications company in Australia, serving more than 2 million customers across 8 countries, has been linked to shortcomings in its internal governance. These deficiencies encompass weaknesses encompasses in internal frameworks, processes, audit standards, and the board's oversight of management. Second, we have the bankruptcy of HIH insurance. Problematic internal governance, including issues such as dysfunctional board operations and the absence of independence within the internal audit committee and external auditors, was cited as a significant factor in challenges faced by the company, which was a leading provider of various insurance services in Australia. This is the reference list, and hope we have a great presentation.